Hello. Welcome to my channel right here on YouTube. Glad to see you. Glad you could be here. Glad you could join me. So don't forget to hit that like button, subscribe button, comment. So my channel right here on YouTube, I have two channels I just created that I'm going to be building content for, all strictly business related, no gossip, just business related. This channel right here is Shirley's Chatter channel. So just gonna give you, some business information, everything from marketing to advertising, promoting, target markets, TQM, total quality management, continuous improvement, some law terms, business terms, accounting. I may be doing some accounting equations, but let's get started with a few law terms. Get started with a few law terms. First, I want to talk about the 27 amendments to the Constitution of the United States of America. Okay, we have Amendment 1, freedom of religion, speech, freedom of the press. So your First Amendment rights, you can basically, you have freedom of speech, but it still has some guidelines when it comes to freedom of speech. You can't say, hurtful things to people. You can't threaten nobody. So you do have freedom of speech, which is the First Amendment. Freedom of speech, religion, and freedom of the press, and freedom to assembly. But you can't threaten nobody, and it's a cutoff. So check with your First Amendment, check with your First Amendment stipulations, because you can say what you want. We do have our First Amendment right, but we still have to be careful what we say. And we have the Second Amendment, the right to bear arms and set up a militia. Then we have Amendment 3, the quartering of soldiers in homes is prohibited. Amendment 4, search and seizure by probable cause. So police officers must have a probable cause. That means that's a reason. They would have to have a reason before they can, just come in and search your home. And then when they search in your home, they would have to have, in other words, they have a search warrant from time to time. They might not have to have a search warrant if it's a danger to their life. Because they do have this no-knock warrant, and then they have times when they don't need a search warrant, when they feel that the defendant may try to, get rid of evidence before they get there, or the defendant trying to get rid of evidence, or it's a danger to the officer's life. They don't have to have a search warrant. But I should be getting into those type of things probably further in my law book. So number 4, search and seizure by probable cause. So like I said, that's a reason to search. And then the search warrant must have, the location and the places that they're going to search. That has to be included in the search warrant. They just can't come in your house and search your whole house. So then we have Amendment 5, grand juries, double jeopardy, self-incrimination, due process, and eminent domain. Okay, double jeopardy, grand juries, self-incrimination, the Fifth Amendment. And then we have eminent domain. So the eminent domain, in other words, if government want to come and make access to your property, in other words, you selling it to them, they will have to compensate you. That's eminent domain. Then we have Amendment number 6, procedures allowed in criminal cases. Procedures allowed in criminal cases, that's like due process, so everybody is entitled to a fair trial. Then we have Amendment 7, jury trials and common law cases guaranteed. So jury trials and common law cases are guaranteed, so you're guaranteed a trial, due process. Due process means fair trial, so we all are entitled to a fair trial. And sometimes they do give you a plea deal. You might not have to go to trial depending on your case. Then we have number 8, Bill of Rights guaranteed, cruel and unusual punishment prohibited. So there can be no cruel and unusual punishment. So you have to go by the book and implement the proper punishment. So cruel and unusual punishment prohibited. There can't be no, out of the ordinary punishment. Anything I don't want to say, but out of the ordinary punishment. But go by the book, go by the law, strictly go by the law. Then number 9, people retain other rights. Number 10, powers reserved to the states. Amendment number 11, lawsuits against the states. Amendment 12, president and the vice president elected. So Amendment 12, that's when they elect the vice president and the president. So Amendment 13, that's when slavery was abolished. Amendment 14, equal protection of the law, due process, citizenship. So equal protection of the law. So we all are equally protected under the law and due process. That means a fair trial for all the citizens. Voting rights guaranteed. So everybody's able to vote. That's Amendment 15. Amendment 16, income taxes established. Amendment 17, senators elected by direct election. 18, prohibition established. Amendment 19, women given the right to vote. Women given the right to vote. Amendment 19, Amendment 20, terms of president, vice president, senators, and representatives altered. Amendment 21, prohibition repealed. Amendment 22, president's terms limited to 2. So president can only serve 2 terms. So each term is 4 years. So there's 8 years that president can serve, only 8 years. Amendment 23, Washington, D.C. gets electors. Amendment 24, poll taxes outlawed. Amendment 25, disability of the president, vacancies in the vice presidency. So disability of the president, vacancies in the vice presidency. So I guess that means if something happens to the president, then the vice president will move up into the presidential spot. Amendment 27, Congress prevented from voting itself instant pay raises. So Congress cannot vote itself instant pay raises. That's amendment number 27. So let's see. Let's talk a little bit about real property. So I want to talk a little bit about real property, the ground and everything permanently attached to it is real property. It includes buildings, fences, and trees on the surface, earth, rocks, and minerals under the surface, and the airspace above the surface. So if you purchase a house, then you own the airspace. You own the surface around the house, the airspace, the rocks, in other words, the surface. Start out with, first of all, you own that house. Then you own the fences, you own the trees, anything in that yard. In other words, you purchase that house, you have a yard, you own the trees, you own the fences on the surface, the earth, like on the ground, the rocks, the minerals under the surface, and the airspace above the surface. So in other words, you own that house, you own all the airspace around that house. Own the fences, the buildings, any buildings. Well, it won't be no buildings, but if you buy a building, you purchase a building, on that property, you own everything on that property. So in other words, you have a property that you purchase you purchase a property with 3 or 4 buildings, 3 or 4 houses. You purchase all 3 of them, then you own everything around it, everything down on the ground, the airspace. So you own all that. It's called real property. And then we have, let's talk about, we talk about air rights. Air rights. In early England, landowners owned the airspace above their property to as high as the heavens. This law changed with the increased use of the airplane. Modern court decisions have held that landowners own the airspace above their land to as high as they can effectively possess or reasonably control. Then we have water rights. People who own land along the bank of a river or stream are called riparian owners. They have certain rights and duties with respect to the water that flows over, under, and beside their land. Owners of land through which a stream flows own the soil beneath the water. If a non-navigable stream is a boundary line between two parcels of land, the owner on each side owns the center of the stream. If the stream is navigable, however, each owner owns only to the bank of the stream, and the bed is owned by the state. A navigable stream in some states is defined as one that ebbs and flows with the tide. In other states, it is defined as a stream that is capable of being navigated by commercial vessels. And then we have, let's talk about some fixtures. When personal property is attached to real property, it is known as a fixture and becomes part of the real property. Built-in stoves and dishwashers, kitchen cabinets, and ceilings, light fixtures are examples of fixtures. Disagreements sometimes occur over whether an item is a fixture. In other words, you purchase a house, and we purchased a house years ago, my dad and my mom and the family, and so we purchased a house where it did come with ceiling fans and different fixtures that were already there, and that was included in the price of the house. So in other words, when a personal property is attached to real property, it is known as a fixture. So those ceiling fans in every room, that would be called the fixtures in a home. It says that it's also known as a fixture and becomes part of the real property. Built-in stoves and dishwashers, kitchen cabinets, all those are fixtures. Built-in stoves, dishwashers, kitchen cabinets. Let's talk about easement. An easement is the right to use the land of another for a particular purpose. So the right to use the land of another for a particular purpose. Easements are used to give people the right to pass over another's land, to run wires through another's airspace, to drain water onto another's property, and to run pipes underneath someone else's ground. The property to which the right or privilege of easement attaches is called a dominant tenement. In contrast, the property through which the easement is created or extends is known as the servient tenement. An easement may be created in three ways: by grant, by reservation, and by prescription. To create an easement by grant, the owner of the land signs a deed giving the easement to the dominant tenement. To create an easement by reservation, the owner of the land grants to another person the entire parcel except for the easement that he or she keeps. An easement by prescription is an easement that is obtained by passing over another's property without permission openly and continuously for a period of time set by state statute, 20 years in many states. Then we have estates in fee simple. Anyone owning real property outright, that is forever, is said to have an estate in fee simple. The estate descends on the death of the owner to the owner's heirs. The owner of an estate in fee simple has absolute ownership in the real estate, with the right to use or to dispose of it is desired, so long as the use of it does not interfere with others' rights. Then we have life estates. So a person who owns real property for life or for the life of another owns an interest in real property called a life estate. Such an estate may be created by deed, by will, or by law. When the terms of a deed or will state that a property is to pass at the end of a life estate to someone other than the grantor or the grantor's heirs, the future interest is a remainder estate. And then we have a tenancy in common. When two or more persons own real property as tenants in common, two or more persons own real property. Each person owns an individual share of the whole property. It says the co-tenant's share of the property passes to his or her heirs upon death rather than to the surviving co-tenants. Each co-tenant is entitled to possession of the entire premises. This is known as unity of possession. Tenants in common have the right to sell or to deed away as a gift their share in the property. Then we have a joint tenancy, when two or more persons own real property as joint tenants. The estate created is single estate with multiple ownership. So joint tenancy, when two or more persons own real property as joint tenants. So in other words, when my mom passed away, we were all, the family, brothers and sisters, about 5 of us. We had, went to a lawyer's office and we became all part of the joint tenancy. We were all part of the joint tenancy because it says when two or more persons own real property as joint tenants, but we were all joint tenants. The estate created is a single estate with multiple ownership, so we all own a portion of the house. Each tenant owns the entire estate subject to the equal rights of the other joint tenants. Four unities must be present to create a joint tenancy: time, title, interest, and possession. Tenancy by the entirety. A tenancy by the entirety may be held only by a husband and wife and is based upon the common law doctrine known as unity of person. Under this doctrine, a husband and wife are regarded in law as one. In theory, each spouse owns the entire estate, which neither can destroy by any separate act. The husband, however, has the entire control over the estate, including the exclusive right to possession and the right to all rents and profits. Upon the death of either spouse, the surviving spouse owns the entire estate outright. Advantages of this type of tenancy are that both parties must agree to any sale or conveyance of the property. So they both have to agree. So it's the tenancy by the entirety. And then execution by a judgment creditor resulting from an action against a husband or wife alone may not be placed against the property. Tenancy in partnership. Ownership of real property by partners is called a tenancy in partnership and is governed by the Uniform Partnership Act in those states that have adopted it. This type of co-ownership of real property, that's discussed further in chapter 36. And then we have, we have a title by sale or gift. By sale or gift, title by sale or gift. Then we have the general warranty deed and the special warranty deed. General warranty deed, sometimes called a full covenant and warranty deed, contains express warranties under which the grantor guarantees the property to be free of encumbrances created by the grantor or by others who had title previously. It is the most desirable form of deed from the point of view of the grantee because it warrants. It gives assurances that title is good. So that's a general warranty deed. Then we have the special warranty deed. Special warranty deed contains express warranties under which the grantor guarantees that no defect arose in the title during the time that the grantor owned the property. We have the bargain and sale deed, the quit claim deed. I heard about that one. Quit claim deed is one that transfers to the buyer only the interest that the seller may have in the property. This type of deed merely releases the party's rights to the property. It contains no warranties. It is used when one gives up some right in the property, such as an easement or dower and courtesy, or to cure a defect in the chain of title. And then we have, I don't want to read all, okay, here go eminent domain. Eminent domain, all ownership of private property is subject to the government's superior rights if property is needed for purposes of public good. Eminent domain, also called condemnation, is the right of federal, state, and local governments or other public bodies to take private lands, with compensation to the owners for public use. Yes, I know my grandmother, years ago, they took part of her land to, build a highway down south. Yeah, so government came and wanted part of her property because they wanted to build a highway. So the right of eminent domain is not available to persons or businesses when taken for private profit. So that's the end of that. We have the tenancy at will. Tenancy at will and tenancy for years. Tenancy at will is an ownership interest in real property for an indefinite period of time. Then we have the tenancy for years is an ownership interest in real property for a definite or fixed period of time. Tenancy for years. It may be for 1 week, 6 months, 1 year, 5 years, 99 years, or any period of time as long as it is definite. So tenancy for years, man, it can go on for years and years. As long as it's definite, then it can be considered a tenancy for years. So, talk a little bit about wills, intestacy, and trust. So this chapter right here, wills, intestacy, and trust. It says, let's start out with testate. A person who dies with a will is said to die testate. A person who dies without a will is said to be intestate. So you die without a will, intestate. You die with a will, testate. A person who makes a will is called a testator. If a man or testatrix, or if a man dies, if a man makes a will, he's called a testator. If a man, but if it's not but if a woman is a testatrix. Testatrix is a woman. So a person who makes a will is called a testator. If a man or a testatrix, if it's a woman. They refer to people of either man, male or female. Personal property that is left by will is called a bequest or legacy. So personal property that is left by will. So if somebody leaves you some property, that means, sometimes you look at some shows sometime, and cause I know I was looking at one show, I think it was on Lifetime, and then they said, something happened to some people in the family, and they said, well, hey, let's come all meet in this room for the reading of the will. And they said, well, blah, 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 bequest you $1 million in the will, bequest you this property, this estate. So bequest. So personal property that is left by will. So somebody had a will and they left somebody something. They said, well, I bequest this, bequest you $1 million, bequest you this estate, bequest you my 2 dogs, bequest. And then we have real property that is left by will is known as a devise. Those who receive property by will are referred to as beneficiaries. They are also known as legatees. If they receive personal property as devices. If they receive real property under a will. The term heir is a broader term referring to one who inherits property, either under a will or through someone dying intestate. So somebody died intestate, then they still might have some heirs, family members that they pointed out as an heir, if they didn't have a will. It says the term heir is a broader term referring to one who inherits property either under a will or through someone dying intestate. So in other words, saying if you have a will or you don't have a will, if a person died and they had a will, whether they had a will or not, they still may have had heirs to the throne, heirs to their estate. So then we have a term given to the quality of state or one who dies without having prepared a valid will is intestacy. The deceased personal property is distributed according to the laws of interstate succession of the state where the deceased was domiciled at the time of the death. Then we have the rights of the surviving spouse. Under a typical statute, if a person dies intestate without a will, the rights of the surviving spouse are as follows. If the deceased is survived by issue, if the deceased is survived by children, grandchildren, great-grandchildren, the surviving spouse is entitled to 1/2 of the estate. If the deceased is survived by no issue but by blood relatives, the surviving spouse is entitled to $200,000 plus 1/2 of the remainder of the estate. The rights of other heirs. Under the same typical statute, if a person dies intestate, they die without a will, the property will pass subject to the rights of the surviving spouse as follows. If the deceased is survived by issue, the property passes in equal shares to the deceased children, with the issue of any deceased child taking their child's share. If the deceased is survived by no issue, the property passes in equal shares to the decedent's father and mother, or the survivor of them. If the deceased is survived by no issue and no father or mother, the property passes to the deceased brothers or sisters, with the issue of any deceased. So in other words, I guess they're saying that it says under the same typical statute, if the person dies without a will, and the property will pass subject to the rights of the surviving spouse. So if they die without a will, then the property will pass subject to the rights, certain rights of the surviving spouse. It says if the deceased is survived by issue, the property passes in equal shares to the deceased children. So in other words, I guess if the deceased, if one spouse died and they don't, in other words, if the father died and then and his wife died before him, and then he died, then the next in line would be the children. If the deceased is survived by issue, the property passes in equal shares, so the children will equally divide. The property is passed in equal shares to the deceased children, with the issue of any deceased child taking their child's share. So when people die owning assets, their estates must be probated. So that is settled under the supervision of the court. The court that supervises the procedure is called a probate court. A probate court in some states, and a surrogate court or orphans court in other states. So the person, if appointed, is called an administrator, and then, or if that's a male, but a female is a administratrix. So the first step in probating an estate is to determine whether the deceased left a will. If a will exists, it usually names a personal representative called an executor, which is a male, executrix, female, who is the person named in the will to carry out its terms. If there is no will, or if the executor or executrix named in the will fails to perform, someone must petition the court to settle the estate. And if they want to settle their estate, that person, if appointed, is called an administrator, which is a male, or administratrix, female. So then let's talk about some trust. A trust is a legal device by which property is held by one person, the trustee, for the benefit of another, the beneficiary. And then that's the end of that chapter. So we'll talk a little bit about partnerships. Okay, partnerships. General partnerships are governed by the Uniform Partnership Act, UPA. Most states have enacted provisions from the UPA. The UPA defines partnership as an association of two or more persons to carry on the business for profit. So then we have partnership losses. Another partnership characteristic is that all partners share in the losses. So all partners share in the losses of the partnership. Losses are shared in the same way that profits are shared. So you're in a partnership, 2 or more people, you're going to share in the losses, and you're going to share in the profits. Unlimited liability, perhaps the most unattractive feature of a partnership is each partner's unlimited liability. So unlimited liability, so there's no end to your liability when you're forming a partnership. So you will be liable for so many things. No end, unlimited. Unlimited means there's no end. No end to the liability that you may encounter. See, unlimited liability. Perhaps the most unattractive feature of the partnership is each partner's unlimited liability. Unlimited liability places the partner's owner property at risk. That's why they tell you it's best to get an LLC, limited liability company, that protects your personal assets. Unlimited liability places partner's own property at risk, which means that the partner's non-partnership property can be used to satisfy debts owned by the partnership. In general, a partner's individual non-partnership property cannot be tapped until the partnership runs out of the assets. It is also possible to stipulate in a given contract that non-partnership property would never be used to satisfy debt arising out of that agreement. Finally, partners can take out insurance to protect themselves against the loss of individual property due to partnership indebtedness. And then we have articles of partnership, the written agreement that establishes a partnership is called the partnership agreement or articles of partnership. And then we have partnership by estoppel, formation by estoppel, when an individual says or does something that leads a third party to the reasonable belief that a partnership exists. Partnership by estoppel occurs. A person's silence despite a duty to speak may also result in a partnership by estoppel. Partnership by estoppel does not create a true partnership. It is a doctrine used by the courts to prevent injustice. However, it benefits only innocent, misled third parties, never the alleged partners themselves. So let's see. Let's talk. Let me say. Tenancy in partnership. Each partner has a property interest in specific terms of partnership property, making him or her a co-owner of that property. This form of ownership is known as tenancy in partnership. A tenancy in partnership has the following characteristics. A partner has an equal right with partners to possess and use specific partnership property for partnership purposes, but not for that partner's personal use. So then we have, let's talk about the fiduciary duties. A fiduciary is a person who has a duty to act for the benefit of another because of their joint undertaking. Partners are fiduciaries to one another. So you're in a partnership, you are fiduciaries to one another. Liabilities, the liability for torts committed by a partner or an employee of the partnership is joint and several. Each partner is liable and may be sued in a joint action in which all partners are named as defendants. So in a partnership, if you sue one partner, you sue all partners. All partners can be sued. Each partner is liable and may be sued in a joint action in which all partners are named and defendants in several actions or individually. A judgment may be levied against one or more partners. The release of one partner in one action does not necessarily release the others. Partners who commit crimes are separately liable. So partners that commit crimes, they're liable separately. Right, because I wouldn't want to think that I'm in a partnership and they go out, one partner go out there and commit a crime, that would say, no, you know what? So if one partner go out there and commit a crime, then they're going to be liable by themselves. So dissolution of the partnership. A partnership comes to an end by way of a two-part process, dissolution and winding up. The UPA defines dissolution of a partnership as a change in the relation of the partners caused by any partner ceasing to be associated in the carrying on of the business. So you have a partnership and somebody wants to, dissolve the partnership, get out of the partnership, get out of the business. So dissolution is to be distinguished from the winding up and termination of the partnership, which effectively puts it out of business. Winding up involves completing all ongoing business and selling the partnership property to obtain cash to satisfy all debts owed by the firm. If anything is left, it is distributed to the partners according to the partnership agreement or the rules set down by the UPA. So in other words, you're in a partnership business, and you want to dissolve. You want to be done. You want to wind it up. You don't want to be involved in that partnership anymore. So they have to sell off all the property, probably pay all the debts off. In other words, creditors and debtors that debts that they owe. So dissolution is to be distinguished from the winding up and termination of the partnership, which effectively puts it out of business. Winding up involves completing all ongoing business and selling. In other words, they have some other unfinished businesses or contracts that they may need to complete, but they don't want to, be in breach of contract. So finish all their ongoing business situations, I guess I would say, all business involvements, and then finish all those up, sell all the property related to the business, and get the cash, and then probably pay, the debts that they owe, and so they can go ahead and dissolve their partnership. Methods of dissolution. A partnership dissolution can occur in a number of ways. Dissolution by acts of the partners. A partnership may be dissolved without the partner liability by the termination of a time period specified in the agreement, the occurrence of an agreed upon event, or the completion of a purpose called for in a partnership agreement. Then we have dissolution by operation of law, dissolution by court decree. So dissolution by court decree, when partners cannot work out their differences by agreement, one or more of them may petition a court for a decree ordering a dissolution or recognizing that one has taken place. So in other words, you're in a partnership and y'all couldn't come to no decision or how y'all going to dissolve this partnership. So you have to ask for the court's help. Dissolution by court decree. So whenever partners cannot work out their differences by agreement, one or more of them may petition the court for the court's help to help them dissolve their partnership. So we have a limited partnership, general partners, and limited partnership, limited partners, and then we have limited liability. So we have a limited partnership. Limited partnerships are governed by the Revised Uniform Limited Partnership Act. The Revised Act defines a limited partnership as a partnership formed by two or more persons, having one or more general partners and one or more limited partners. Then they have one or more limited partners. This is a limited partnership. They have one or more general partners and one or more limited partners. Then they have the general partners take an active part in the management of the firm and have unlimited liability for the firm's debts. So general partners, they have unlimited liabilities for the firm's debts. Then we have limited partners. They are non-participating investors. Limited partners, so that's what, read into the word limited. Limited, that means they don't have much say in their partnership. So it says they are non-participating investors. In other words, they invest, but they don't have a lot of say in the partnership. So those are limited partners. They contribute cash, property, or services to the partnership, but do not take part in the management of the firm. So those are the limited partners. And that is that. So this was this book, Business Law. So, and then I wanna, let me see, I have a couple other things to read over. So this is criminal law and procedure. And this is we'll talk a little bit about constitutional defenses, just a couple of them. What about double jeopardy? Second prosecution by the same government against the same person for the same crime. Once the first prosecution is totally finished and decided, this is prohibited by the U.S. Constitution. So the double jeopardy clause applies only to criminal proceedings. There are actually two prohibitions in the double jeopardy clause. The clause prevents a second prosecution for the same offense and a second punishment for the same offense. So you can't be tried twice for the same offense. It says the Fifth Amendment to the United States provides that no person shall be subject for the same offense to be twice put in jeopardy. In other words, you can't be tried twice for the same offense. Then we come over here to self-incrimination. That's coming, I think that's the Fifth Amendment. Yeah, the Fifth Amendment also states that no person shall be compelled in any criminal case to be a witness against himself for fear of self-incrimination. So you had to participate in a crime. I mean, not a crime, but you had to participate in the trial. You had, because they called you as a witness. But then you get on the stand and you're like, oh no, you talk to your lawyer ahead of time, and you're like, that line of questioning, that I know that he's going to bring forward to me. I think when I get on the stand, but you let your lawyer know, when I get on the stand, I'm going to plead the fifth for fear of self-incrimination. See, the Fifth Amendment also states that no person shall be compelled in any criminal case to be a witness against himself. So you don't want to testify against yourself, but you might get on the stand and say something that may incriminate you, and that's what you don't want to do. So you want to invoke your Fifth Amendment right. Your Fifth Amendment right. Perhaps the best known provision of the Fifth Amendment is a clause against forced self-incrimination, whose origin goes back to England, where a person was accused of crime before ecclesiastical courts were forced to take an ex officio oath. That is, they had to swear to answer all questions, even if the question did not apply to the case at the trial. So this was back in England. Back in England, where they couldn't invoke the Fifth Amendment. No, they couldn't invoke the Fifth Amendment from the United States Constitution, or even the Constitution of their own state, England, or their own country, whose origin goes back to England, where a person is accused of crimes before ecclesiastical courts were forced to take an ex officio oath. So they had to take an oath, under oath, saying that they're going to answer all the questions, so they couldn't, it wasn't no, hey, you can plead the fifth. There wasn't none of that. So you can't plead the fifth. You couldn't have pled the fifth. That is, they had to swear to answer all the questions if the questions did not apply to the case at trial. The requirement was later adopted by the Court of Star Chamber. One of the victims of the court was a printer and book distributor named John Lilburn, charged in 1637 with treason for importing books that promoted Puritan descent. Lilburn told his accusers, "I am not willing to answer to you any more of these questions because I see you go about by this examination to ensnare me. For seeing the things for which I am in prison cannot be proved against me. You will get another material out of my examination. And therefore, if will not ask me about the thing laid to my charge, I shall answer no more. I think by the law of the land that I may stand upon my just defense. Lil Byrne was convicted, fined, whipped, pilloried, and gagged, and imprisoned until he agreed to take the oath. So he was put in prison, and all these things happened to him until he agreed to take the oath. Because he was like, I am not going to keep on asking these questions because you are trying to ensnare me. For seeing the things for which I am in prison cannot be proved against me. So in other words, he felt that the things that they were trying to charge him with could not be proved against him. They were trying to snare his name. And but they treated him real bad and did all those things to him. They gagged him and imprisoned him until he agreed to take the oath. So they were trying to get him to take the oath to answer all the questions. So like I said, it wasn't no, you can plead the fifth. Well, no, you can plead the fifth. Then we got transactional immunity, freedom from prosecution for all crimes related to the compelled testimony, so long as the witness tells the truth. Shields the witness from prosecution for all offenses. Shields the witness from prosecution from all the offenses related to his or her testimony. Then we have the use immunity, freedom from prosecution based on the compelled testimony and on anything the government learns from following up on the testimony. The minimum immunity that must be provided a witness to overcome a Fifth Amendment claim is derivative use immunity. This prohibits the government from using the witness's testimony or any evidence derived from that testimony to prosecute the witness. So in other words, use immunity keeps the government from being able to use your own evidence. You're a witness, they won't be able to use evidence against you. In other words, you testify, and then they say what you understand testifying, and they can use that information against you. But that's what I call this use immunity. This prohibits the government from using the witness's testimony. So in other words, you understand, and they're cross-examining, when they're examining you, cross-examining you, questioning you, rather. And so use immunity, it keeps the prosecution from using your witness statements against you. So then we have due process and equal protection. The Fifth Amendment to the United States Constitution prohibits the government from depriving a person of life, liberty, or property without due process of law. This amendment acts to constrain the power of the federal government. You have previously learned that the Fourth Amendment has similar language and constrains the power of state governments. The Fourth Amendment expressly requires the states to extend equal protection of the laws to the people. Principle of legality. This procedural side of due process which requires that criminal laws be written and enacted before an act may be punished. And then we have, we have the vagueness doctrine. The vagueness doctrine is the rule that a criminal law may be unconstitutional if it does not clearly say what is required or prohibited, what punishment may be imposed, or what persons may be affected. A law that violates due process of law in this way is void of vagueness. We have the overbreadth doctrine. Overbreadth. A law will be declared void for overbreadth if it attempts to punish speech or conduct that is protected by the Constitution, and if it is impossible to eliminate the unconstitutional part of the law without invalidating the whole law. And then we have ex post facto law. Is one that makes an act illegal after the act was taken. Increases the punishment or severity of a crime after it occurred. Changes the procedural rules so as to increase the chances of conviction after the crime occurs. In short, a government may not make criminal law retroactive. if doing so is detrimental to the defendant. So, let me see, I think that. So it's just some cases in the back. And, all right, let's talk about the Fourth Amendment. So, searches, seizures, and arrests, the Fourth Amendment. So until 1967, the Fourth Amendment had been interpreted to protect areas. For a violation of the Fourth Amendment to occur, law enforcement officers had to physically trespass upon the property of the defendant. This standard was changed to Katz versus the United States. In Katz, the Supreme Court held that the Fourth Amendment protects people, not places. The court established a two-part test to determine if the Fourth Amendment is implicated. First, an individual must have a subjective expectation to privacy. Second, that expectation must be objectively reasonable. The Katz reasonable expectation of privacy test continues to be the method of determining whether a search or seizure has occurred. Consistent with Katz, the Supreme Court has defined a search as when an expectation of privacy that society is prepared to consider reasonable is infringed. In the same opinion, the court defined a seizure as a meaningful interference with an individual's possessory interest in property. If there is no invasion of a reasonable expectation of privacy, there is no search. For example, a police officer's observations made from a public place, such as a sidewalk, are not searches, even if they are of the inside of a house through a window. Observing the exterior of an automobile, including a license plate, is not a search, nor is a dog sniff of an item or person. Every case presents different facts. Accordingly, the determination of whether a defendant's expectation to privacy is reasonable is fact sensitive. However, there are Supreme Court cases holding as a matter of law whether an expectation to privacy is reasonable in a given context. So I'm not going to read all that. But let's talk about probable cause. Probable cause defined. The Fourth Amendment requires the existence of probable cause before warrants are to be issued. So like I said previously, probable cause, they have to have a reason or, reasonable suspicion. That reasonable suspicion that they think they're going to find something, When a warrant is first obtained, the probable cause determination is made by a judge. In cases where a police officer acts without a warrant, the officer makes that determination. In both cases, as you will see, probable cause is required. Probable cause is a phrase describing the minimum amount of evidence necessary for a search, seizure, or arrest to be proper. See, probable cause is a phrase describing the minimum amount of evidence necessary for a search or seizure or arrest to be proper. There is no one universal definition of probable cause. In fact, the definition of probable cause differs depending on the context. In all situations it is more mere suspicion and less than the standard required to prove a defendant guilty at trial. So beyond a reasonable doubt. As the Supreme Court has expressed, probable cause is present when the trustworthy facts within the officer's knowledge. Trying to see where it starts, where it begins back. Oh, here it is right here. So it says, as the Supreme Court has expressed, probable cause is present when the trustworthy facts within the officer's knowledge pursue a warrantless search or seizure. Are sufficient in themselves to justify a person of reasonable caution in the belief that seizable property would be found or that the person to be arrested committed the crime in question. Searches and seizures, the warrant requirement, depending upon the circumstances, the search may be conducted with or without a warrant. So as I was talking about previously, sometimes they may not need a warrant. In other words, if the officers' lives are in danger and they don't have time to get a warrant, or they fear that the suspect or defendant will do away with evidence. So I said the Supreme Court has expressed that there is a strong preference for the use of warrants when possible over warrantless actions. The warrant preference serves an important purpose. It protects citizens from overzealous law enforcement practices. Yeah, so so it protects us over overzealous officers. Accordingly, a search conducted pursuant to a valid search warrant is per se reasonable. A search conducted pursuant to a valid search warrant is per se reasonable. Warrantless searches are permitted only in special circumstances. So warrantless searches. And it is the responsibility of the government to prove that the facts of the case fit into one of the exceptions to the warrant requirement. To give this preference some teeth, the Supreme Court in Aguilar versus Texas, 378 United States 108, 111, 1964, announced that when a search is based upon the magistrate's rather than a police officer's determination, so in other words, it's based on a judge's determination instead of a police officer's determination of probable cause, reviewing courts are to accept lesser competent evidence than if the officer made the determination personally, so long as there was a substantial basis for the magistrate's decision. To say it another way, less evidence is required to sustain a search if a warrant was obtained prior to the search. So in other words, if they went to the judge, or the officer went to the judge and, requested a search warrant, that's what they said, to say it another way, then it'd be less evidence. It'd be a less evidence requirement to sustain a search warrant. So in other words, they go to the judge, they might not need that much evidence to get that search warrant from the judge. See, to say it another way, less evidence is required to sustain a search warrant if it was obtained prior to the search. Obtained prior to the search. Reviewing courts are referred to because the determination that probable cause exists by a magistrate when issuing a warrant is not final. Reviewing courts are referred to because the determination that probable cause exists by a magistrate when issuing a warrant is not final. A defendant may later attack any evidence seized pursuant to a warrant through a motion to suppress. Motion to suppress evidence if you feel, as a defendant that it was obtained illegally. I think it's a term too we learned called fruit of the poisonous tree. So if they obtain that evidence illegally, then, you can put a motion in to have the evidence suppressed. I'm not a lawyer, but I remember a lot of these terms. Reviewing courts are referred to because the determination that probable cause exists by a magistrate when issuing a warrant is not final. A defendant may later attack any evidence pursuant to a warrant through a motion to suppress. As stated, determinations by a magistrate are less likely to be overturned than those made by a police officer. The Supreme Court created an exception to the rule that evidence must be suppressed if seized pursuant to an invalid warrant in the United States versus Leon. This is a case 468, United States 897, 1984. Requirements for obtaining a warrant. The Fourth Amendment enumerates the requirements that must be met before a warrant can be issued. It is the responsibility of the law enforcement officer requesting a warrant to establish these elements to the judge, making a warrant determination. The form application for a search warrant used in the federal courts appears. See, first, the evidence presented must establish probable cause to believe that within the area to be searched, the items sought will be found. Second, there must be probable cause to believe that the items sought are connected to criminal activity. So they would have to prove this to the judge before they can even get this search warrant. So officers, they want to try to get a search warrant. They have to the evidence presented must establish probable cause to believe that within the area to be searched. So in other words, they're thinking about where they want a search warrant from the judge, and they want to let the judge know that, when we go search this certain area in this person's home, apartment, or house, or whatever, then we're going, we're pretty confident that it's going to be there. What's going to be there is what we're looking for. So first, in other words, the evidence presented must establish probable cause to believe that within the area to be searched, the items sought will be found. And second, there must be probable cause to believe that the items sought are connected to the criminal activity. Third, the area to be searched and any item to be seized must be described with particularity. The amount of specificity required varies from case to case. A warrant that authorizes a police officer to search a particular home for unauthorized contraband clearly violates the Fourth Amendment, whereas a warrant authorizing the search of the same home for a 9-inch knife with an ivory handle is valid, provided the warrant is valid in all other respects. Probable cause warrants for the seizure of items that are illegal in themselves do not have to be as particular as others. For example, a warrant to search for a book must be more specific than one for drugs. The description book is clearly insufficient, whereas a warrant to search for cocaine probably is sufficient. And this is application and affidavit for search warrant. So I'm already at an hour, so this is what they do. They ask, this is the United States District Court. Okay, let's see. Let's talk about the plain view doctrine, the rule that if police officers see or come across something while acting lawfully, that item may be used as evidence in a criminal trial, even if the police did not have a search warrant. See, so the rule that if police officers see or come across something while acting lawfully, that item may be used as evidence in a criminal trial if the police did not have a search warrant. So in other words, you stopped at a traffic light and you have, and the police pull you over and tell you to put your window down, and they happen to see some contraband right on your passenger seat, right on your passenger side seat of your car, and they tell you to, pull your window down. And so that would be considered under the plain view doctrine, that could be used as evidence against you in court. So the officer, pull you over and say, you were speeding, you ran a stop sign, and they pulled you over, then they told you, the officer said, pull your window down, he smelled marijuana, and then he just happened to see, contraband, marijuana, in the passenger side, on the passenger side seat of your car. So that would be considered plain view doctrine because it's right in the officer's view where he can see it. See, the rule is that if a police officer see or come across something while acting lawfully, so in other words, he was acting lawfully in the regular course of his business, his work time. He was on a job. While acting lawfully, that item may be used as evidence in a criminal trial, even if the police did not have a search warrant. So he had to have a search warrant. So they call it the plain view doctrine. So plain view doctrine, let's talk about stop and frisk. Stop and frisk. A Cleveland, Ohio police detective served 3 men. It said he served 3 men. Served 3 men. That must be a misprint. Detective. Oh, observed. Okay, I see. I didn't see the two letters. Observed 3 men standing on a street corner. Suspicious of the men, the detective positioned himself to watch their behavior. So he watching them, they stand on the street corner and they look kind of suspicious. So he was just watching them. He said, suspicious of the men, the detective positioned himself to watch their behavior. So he's just watching them. That's what they always do. After some time, the officer concluded that the men were casing a job. They were casing a job and stick up. I mean, he was just assuming they were, just because they were standing around. He said he was observing them. And I guess he felt that they looked suspicious to him, that they might was probably about to stick up the store or something, which can be just a, wrong assumption. Could be right, could be wrong. The officer approached the men, identified himself, and asked them to identify themselves. After the men mumbled something, the officer grabbed one of the men and conducted a frisk or pat down of the man's clothing. The officer felt a pistol in the man's coat pocket. He removed the gun from his coat and then patted down the other 2 men. Another gun was discovered during those frisks. The officer testified that he conducted the frisk because he believed the men were carrying weapons. The first man frisked was defendant Terry. That's what they told. That's how we got the Terry stop. At trial, he was convicted of carrying a concealed weapon. Was subsequently sentenced to 1 to 3 years in prison. His appeal made it to the United States Supreme Court in Terry versus Ohio, 392 U.S. 1, 1968. The Supreme Court was confronted with these issues. Did the officer's behavior amount to a search or seizure under the 4th Amendment? If so, was the search or seizure by the officer reasonable? So that was a stop and frisk. The court decided that defendant Terry had been seized under the 4th Amendment. It must be recognized that whenever a police officer accosts an individual and restrains his freedom to walk away, he has seized that person. So if they restrain you and you can't walk away, they call that, they seized that person. They seized you. As to the frisk, the court stated that it's nothing less than sheer torture of the English language to suggest that a careful exploration of the outer surfaces of a person's clothing all over his or her body in an attempt to find weapons is not a search. With these statements, the court made it clear that the police practice of stopping and frisking people is one governed by the 4th Amendment. However, the court then concluded that an exception to the probable cause requirement was justified because the intrusion upon a person's privacy is limited in a stop and frisk, as opposed to an arrest and full search. Officers are not given carte blanche to stop and frisk, although probable cause is not required. So stop and frisk, they don't have to have no probable cause. It's I guess that reasonable suspicion. So they don't have to have no probable cause. You walking down the street and they can look at you and you look suspicious, then they can perform a stop and frisk. Although probable cause is not required, officers must have a reasonable suspicion that the person to be stopped is committing or is about to commit a crime. The officer's suspicion must be supported by specific articulable facts which, taken together with rational inferences from those facts, reasonably warrant that intrusion. So I'm not going to read all that. Then we have the plain field doctrine. So we had the plain view doctrine. And now we have the plain field doctrine. Plain view, where, like I said, the officer, you on the way home from work, and the officer stopped you because you were speeding, or you ran the traffic light, you ran a stop sign, and he told you to roll your windows down, and in his ordinary course of business, doing his job, you roll your windows down, and he sort of contraband in your passenger side seat, so it was in plain view. So that evidence could be used as evidence against you in trial, at your trial. Plain field doctrine, we'll just say plain field. You have learned the plain view doctrine and the Terry exception to the warrant and probable cause requirements for the Fourth Amendment. The plain field doctrine is a product of their joining. That is, what happens when an officer who is conducting a Terry pat down, in other words, they stop you, hit you with a stop and frisk. All they needed was that reasonable suspicion. They did a stop and frisk. And then, next thing you know, it's going to be a plain field. So the plain field doctrine. So it says the plain field doctrine is a product of their joining. That is, what happens when an officer who is conducting a Terry pat-down discovers through the sense of touch, not a weapon but contraband. May this information be used to establish probable cause allowing a mere intrusive search. This question was answered in the Dickerson case. If an officer discovers contraband through the sense of touch during a Terry frisk, probable cause is to search further. If contraband is recovered, it is admissible at trial. The rules set out in Terry apply. First stops must be supported by reasonable suspicion. Second, pat-downs may be conducted only when an officer possesses a reasonable suspicion based on specific and articulable facts that the suspect may be armed and dangerous. Third, the pat-down must be limited. Exploration of the clothing beyond what is necessary to determine dangerous is not permitted unless probable cause to believe that there is contraband is created through the officer's sense of touch. So it says if an officer discovers contraband through the sense of touch. So in other words, the officer is doing a stop and frisk, and then he's doing a little stop and frisk, and he's going through your pockets, searching your pockets, and then they come across, he's just feeling, and he assumed that if you can't see it, but you're just feeling in the pockets, so that's why I say the sense of touch. But it didn't say that he saw contraband. It says that if an officer discovers contraband, but he discovered it was contraband, but he was just, he was feeling around in the pocket, so he didn't actually see it, what was in your pocket first. He just felt around in your pockets when he did that stop and frisk. So if an officer discovers contraband through the sense of touch during a Terry frisk, probable cause is this to search further. In other words, stop and frisk is not a full stop and frisk is not a full search, but he feeling around. He did a quick little stop and frisk, but then he feeling around. He assumed that it's contraband. I guess once he pulled it out, then after that gives him probable cause to do a full search. So that's what they're saying about plain field doctrine. That gives him probable cause to do a full search, but stop and frisk is not a full search in the beginning. So, it's a lot of other stuff in here. Emergency searches in hot pursuit, open fields, border searches and profiles, motor vehicles and roadblocks, stops, searches where the Fourth Amendment mandates have been reduced is in the context of the warrant requirement in Carroll versus United States. 267 U.S. 132, 1925, some years ago. It was announced that a warrantless search of a vehicle stopped on a public road is reasonable. So a warrantless search on a vehicle stopped on a public road, provided the officer has probable cause to believe that an object subject to seizure will be found in the vehicle. The existence of probable cause is the key to the search. This authority has been extended to permit the search to continue after the vehicle is impounded. So they impound your vehicle, they can still go ahead and go through it and search it. See, it's announced that a warrantless search of a vehicle stopped on a public road is reasonable, provided the officer has probable cause to believe that an object subject to seizure will be found in the vehicle. So the officer, he feels that what he's looking for, if he feels that what he's looking for is in your vehicle, then he don't need a warrant. So your vehicle stopped on the road, because it says it was announced that a warrantless search for a vehicle stopped on a public road is reasonable, provided the officer has probable cause. So if he had probable cause to believe that it's in your car, whatever he's looking for is in your car. See, and it says search of the vehicle stopped on a public road is reasonable. It was announced that a warrantless search on a public vehicle on a public road is reasonable, provided the officer has probable cause. The sticky question in this area is the scope of the search. Generally, an officer is given the scope that a magistrate will have if a warrant were sought. Thus, if an officer has probable cause to believe that a shotgun used in a crime will be found in the car, a search of the glove box is improper. In other words, he still will be searching a certain area of the car. So they're saying officers may also search closed items found in the vehicle, provided probable cause exists to believe an item sought may be contained therein. So it's a lot of good terms in. Let's see. That is it. So let's see. Let's talk about interrogations, confessions, and admissions. And let's talk about Miranda. Interrogation, questioning by police, especially of a person suspected or accused of a crime. Then we have a confession, a voluntary statement by a person that he or she is guilty of a crime. So it's not good to give a confession, I think it would be good to have your lawyer present. And admission is a voluntary statement that a fact or a state of events is true. And then we have Miranda. Contrary to popular belief, the famous Miranda versus Arizona case is not a Sixth Amendment right to counsel case. Rather, the right to counsel theory is founded upon the Fifth Amendment right to be free from self-incrimination. Custodial interrogation. Not all questioning by law enforcement officers must be preceded by the Miranda warnings. A defendant must be in custody and interrogated by police before Miranda has effect. This is known as a custodial interrogation requirement. The court used the phrase taken into custody or otherwise deprived of his freedom of action in any significant way to define the custody element of Miranda. An objective test is used to determine if a suspect is in custody so that the suspect's subjective beliefs or the beliefs of the interrogating police officer are not dispositive. The question is whether a reasonable person would have believed that he or she was not free to leave. Usually, if you're not free to leave, and an officer stops you, and usually they'll tell you that you are under arrest. Because if you're not under arrest, then you can, you can walk away. Although a statement by a police officer to a suspect that he is not under arrest is not dispositive, it may be considered, of course, a person is in custody if an officer announces, as I said, that an arrest is being made or that the person is not free to leave. That's what I'm saying. They usually would tell you, you're under arrest, you are under arrest, and you can't leave. Because you see that right on TV in the movies, so they'll tell you, But the court made it clear that the in custody element may be satisfied anywhere. It is not required that the defendant be at the police station to be in custody. Right, but they can stop you on the street, and then have a reasonable suspicion that, somebody might have just got robbed, and they can just stop you, because it happened around here, in this area where they have stopped a few people different times, and you fit the description of the lady said somebody just robbed her. You fit the description. Now you can't go nowhere. You gotta stay right here, and we're gonna let her come over here so she can see if she can, if she can let us know whether or not you were the person that robbed her, or hit her or did something to her. So we have Miranda versus Arizona. The cases before us raise questions that go to the roots of our concepts of American criminal jurisprudence. The restraints society must observe consistent with the federal constitution in prosecuting individuals for crime. More specifically, we deal with the admissibility of statements obtained from an individual who is subjected to custodial police interrogation and the necessity for procedures which assure that the individual is accorded his privilege under the Fifth Amendment. The Fifth Amendment to the Constitution not to be compelled to incriminate himself. So when it comes to Miranda, they didn't explain it right here, but I went over that in my I think it's here, this right here, but I went over that in one of my other courses, not this course right here. Okay, not every communication between a police officer and a suspect amounts to an interrogation under Miranda. First volunteered statements are not the product of interrogation. The Miranda decision explicitly states that officers are under no duty to interrupt a volunteer confession in order to read a confessor his or her Miranda rights. So in other words, somebody stopped by the police officer, so the police officer is not under no legal duty. In other words, if the person is going to confess, the person is confessing, then the police officer is under no duty to stop that person from confessing to read him his Miranda rights. So that's what it's saying. And so, and it says, second, routine questions that are purely informational normally do not lead to incriminating responses and need not be preceded by a reading of the Miranda warnings. Third, questions made by officers in the interest of public safety need not be preceded by Miranda warning. Questions made by officers in the interest of public safety. Questions made by officers in the interest of public safety need not be preceded by a Miranda warning. The court recognized that in such situations when there is a danger to the officers, as I was saying earlier, the court recognized that in such situations when there is a danger to the officers or the public, officers must be permitted to extinguish the public threat. Thus, the relatively rigid Miranda rules are relaxed when there is public safety exigency that was the impetus of a brief and limited interrogation designed to meet that exigency. Fourth, related to the public safety exception is spontaneous questioning by police. If a question is asked spontaneously, such as in response to an emergency, there is no interrogation. Fifth, the Miranda warnings do not have to be given by the undercover officers because there is no custody no police-dominated atmosphere. However, once criminal charges have been filed, undercover officers may not be used to extract information from a defendant. 6. The Supreme Court has determined that Miranda warnings do not have to be recited during routine traffic stops. Even though an interrogation occurs, the court concluded that although traffic stops are seizures for Fourth Amendment purposes, they are not custodial for Fifth Amendment purposes. So when it comes to the Miranda, so I read about the Miranda versus Arizona. I read about the Miranda case. I think it was one of my other courses. So in other words, his name was Ernesto Miranda, and he was interrogated by the police. He was interrogated by the police. He had stole something from the store, so he was interrogated by the police. His name was Ernesto Miranda, and they didn't read him his rights. So that was his name. So that's how the Miranda rights came about. That's how they came about. And it says the warning: before a person in custody may be interrogated, the required warning must be recited to the arrestee. Specific language need not be used as long as the defendant is fully and effectively apprised of each right. The Supreme Court stated in Miranda that the following rights must be conveyed to the defendant. The right to remain silent. Any statements made may be used against the defendant to gain a conviction. The right to consult with a lawyer and to have a lawyer present during questioning. For the indigent, a lawyer will be provided without cost. A defendant may waive the right to have the assistance of counsel and or to remain silent. Remain silent and invoke your Fifth Amendment right. The waiver must be made voluntarily and knowingly. In Miranda, the Supreme Court said that the heavy burden of proving that a defendant made a knowing and voluntary waiver rests with the prosecution. Courts are to presume no waiver. So, Sixth Amendment, Miranda has effect as soon as a person is in custody and is subject to interrogation. This can occur long before or directly prior to the filing of a formal charge. Once the adversary judicial proceeding has begun, the source of protection changes from the Fifth Amendment to the Sixth Amendment. So, your self-incrimination, that's the Fifth Amendment, is not violative of the Fifth Amendment's privilege against self-incrimination for a defendant to be compelled to appear in a lineup. The privilege against self-incrimination applies to testimony and not to physical acts, such as walking, gesturing, measuring, or speaking certain words for identification purposes. So in other words, you can only use the Fifth Amendment, fear of self-incrimination. In other words, you have to testify against someone in a court of law. So you can only invoke the Fifth Amendment if that's, you're on trial. If you're on trial or you're a witness to a trial, to a case or something, you can only invoke the Fifth Amendment. You don't want to testify against yourself for fear of self-incrimination, because it says the privilege against self-incrimination applies to testimony. So you're giving your testimony in a court of law. That's the only time you can, invoke the Fifth Amendment. So it said it's not violative of the Fifth Amendment's privilege against self-incrimination for a defendant to be compelled to appear in a lineup. So you don't have to appear in a lineup. Defendant's privilege, it says it is not violative of the Fifth Amendment's privilege against self-incrimination for a defendant to be compelled to appear in a lineup. So I think that is all from this. It's a whole lot of stuff in this book. We have, everything. We have the pre-trial process, so it's just so much to learn, I'm not gonna read all that, but that's the pre-trial process. I think that's it. So I might have to, let me see. Let me go over a couple other things real quick. Let me see. I just want to go over. Let's see. I think it's, let's see. Just a couple other things I wanted to, I lost my page. Oh, no, here it is, right here. This is going to be the last one. I'll go over some other stuff next time. Let's talk about the Freudian Revolution. So Freud and the psyche. So I'm just going to read a couple of things from here. Freud was a Jewish intellectual who graduated in medicine from the University of Vienna, Austria in 1880. Was the first to map the subconscious geography of the human psyche. His early work with severely disturbed patients, followed by a period of intensive self-analysis, led him to develop a systematic procedure for treating and curing emotional illnesses. So Sigmund Freud, 1865 to 1939. Freud was the founder of psychoanalysis, a therapeutic method by which repressed desires are brought to the conscious level to reveal the sources of emotional disturbances. Freud invented the principal tools of this method, dream analysis and free association, and found these techniques superior to hypnosis in uncovering hidden disorders. Freud theorized that instinctual drives, especially the libido or sex drive, govern human behavior. According to Freud, guilt from the repression of instinctual urges dominated the subconscious life of human beings and manifested itself in emotional illness. Most psychic disorders, he argued, were the result of trauma stemming from the child's subconscious attachment to the parent of the opposite sex and jealousy of the parent of the same sex, a phenomenon Freud called the Oedipus complex. Freud considered his research on dream analysis. So Freud dealt with a lot of the id, the ego, the superego. He analyzes, he felt that you can analyze your dreams. So in other words, when you dream, it's almost like it's real. It comes like up to your subconscious mind. So it comes up, in other words, it comes to your subconscious mind. It's like dreams are almost real. But when you wake up, it's just a dream. But Freud's more speculative investigations were equally significant. In Totem and Taboo, he examined the function of the subconscious and the evolution of the earliest forms of religion and morality. Freud's theories not only opened the door to the clinical appraisal of previously guarded types of human behavior, they irrevocably altered popular attitudes toward humanality. His controversial writings also had a major impact on the treatment of the mentally ill. Before Freud, people generally regarded psychotic behavior as evidence of possession of demonic or evil spirits. In describing the activities of the human psyche, the human mind, Freud proposed a theoretical model, the terms of which, though often oversimplified and misunderstood, have become basic to psychology, the study of mind and behavior. So Freud, he was a Jewish intellectual, graduated in medicine from the University of Vienna, Austria in 1880. And so he dealt with analyzing, ways to analyze your dreams. So in other words, he dealt with the id, the ego, and the superego. So in other words, he felt that we had sort of like three personalities. We have the id, the ego, and the superego. And Freud, he was the first to map the subconscious geography of the human psyche or mind. So he dealt with the subconscious of your mind. So his early work with severely disturbed patients, followed by a period of intensive self-analysis, led him to develop a systematic procedure for treating and curing emotional illnesses. So he's dealing with the dreams, dealing with dreams and analyzing dreams and your subconscious mind. So in other words, your dreams, when you're thinking that your dreams are real, sometimes when I dream, and when you're in the midst of your dream, it does feel like it's coming to your subconscious mind, because it almost seems like it's a dream until you wake up. It almost seems like it's real. I had many dreams, and I feel like, I'm in the midst of that dream. You can be anything. You could be in a car, or you can see some dogs, or whatever's going on in your dream. It seems like it is suppressed to your subconscious. And then you feel like, it's real, and you just don't know whether or not you sometimes, I don't know, where I'm at. I'm in my dream, but the dream, it really seems real. And I wake up, I'm like, oh no, that dream did seem real. Freud's tripartite psyche constituted the most radical explanation of human behavior since Darwin's law of natural selection. Freud's theory not only threatened to unleash what the 19th century German philosopher Nietzsche had called the wild dogs howling in the cellar of the soul. They asserted that the individual's conscious life was only the tip of a large iceberg, the submerged body of which might be laid bare through clinical analysis. Freud questioned the very nature of human morality. He described benevolent action and altruistic conduct as mere masks of self-gratification. Such views were central to the essay Civilization and Its Discontents, 1930, in which Freud explored at length the relationship between your mind, your psychic activity, and the human society. So dealing with your mind, your psyche. Enumerating the various ways in which all human beings attempt to escape the pain and unpleasure of life, Freud argued that civilization itself was a collective product of sublimated instincts. The greatest impediment to civilization, he claimed, was human aggression, which he defined as an original self-subsisting instinctual disposition in man. The following excerpts offer some idea of Freud's incisive analysis of the psychic life of human beings. So I'm not going to read all this from him, but just maybe a little. Let's see what he's saying. It says, from Freud's Civilization and Its Discontents, we will turn to the less ambitious question of what men themselves show by their behavior to be the purpose and intention of their lives. What do they demand of life and wish to achieve in it? The answer to this can hardly be in doubt. They strive after happiness. They want to become happy and to remain so. This endeavor has two sides, a positive and a negative aim. It aims on the one hand at an absence of pain and unpleasure, and on the other at the experiencing of strong feelings of pleasure. It is in its narrower sense, the word happiness only relates to the last, in conformity with this dichotomy in his aims. Man's activity develops in two directions, according as it seeks to realize in the main or even exclusively the one or the other of these arms. As we see, what decides the purpose of life is simply the program of the pleasure principle. This principle dominates the operation of the mental apparatus from the start. So I'm not going to read all of this, but this is Sigmund Freud. I wish I had a picture, but I don't. I don't have a picture of him, but I want to say thanks for joining me today. Glad you could be here. Glad to see you. So please subscribe to my channel. So like I said, this is one of my channels. I have two, and I'm just trying to build my content. So I will be presenting a lot of different law terms. So I want to explore all the different areas of law and just bring a lot of information to my channel. When I did my research yesterday on the different areas of law, I found that there's so many. We have maritime law, administrative law, we have criminal law, civil law, tort law, we have family law, and there's so many. I think it was, probably close to about maybe 50, maybe more different areas of law. So I just want to bring a little bit of information from each area of law because it's a very good learning experience for me as well. And then I also want to get out in the field and do some blogging, relating to, business, marketing, advertising, promoting, anything related to business. Copyrights, trademarks, part of intellectual property law, copyrights, trademarks, patents. But thanks for joining me today. I'm not going to hold the video too long because it's almost 2 hours. So I know one time my brother, he said, "Sis, I came to your channel, and you was just on, I think it was on one of my other channels, you was just talking." He said he was just talking, and then he said I left and went out the room, came back, you was still talking. I said, yeah, that's the purpose. That's the purpose of creating these YouTube channels, whether you want YouTube, TikTok, Twitter, Instagram, whatever platform, social media platform you are on. You want to, talk, public speaking. You are going to talk. But I'm just learning about, being able to, I can only assume that I would say that I would definitely get better at my public speaking and bringing my information, for my channel. But I want to say thanks for joining me today. Hope you'll come back. Hope you'll subscribe to my channel. If comment below, subscribe below, give me some ideas. Give me some topics that you might want me to talk about, because I will be glad to do some research. And so this video is almost 2 hours long, but I felt that I don't feel, my teacher always said, don't say I feel, say I did bring some valuable information, enlightening information, and so don't ever say, my teacher always said, don't say I feel, just say I did. I said what I said, I did what I did. So thanks for joining me, and I'll see you on my next video. So you all have a blessed one.